Welcome everyone to this JD masterclass on the for equity and trusts on the Trevorrow decision. And I want to begin by acknowledging and celebrating the first Australians on whose traditional lands we are meeting and whose sovereignty was never ceded. They teach us that the land is not ours to own, but a gift to care for and delight in. And so I pay my respects to the elders of the Ngunnawal and Njarrindjeri people, past, present and emerging. And I'm very happy and very grateful to the Honourable Tom Gray, former Justice of the South Australian Supreme Court, who's kindly agreed to talk to us about his judgment in the famous Trevorrow decision. So for those of you who might have to answer a short answer question on this in the final exam, I'll just give you the citation again for the case. For the LLB students who are here, thank you for coming, and you don't have to worry so much about the technical details, but the citation is Trevorrow and State of South Australia, number 5. There's a big matter. 2007, South Australian Supreme Court 285, and it's reported in 2007, volume 98 of the South Australian State Reports at page 136. And I won't spend a lot of time introducing the judge to you because possibly you're familiar with him. He's been here a couple of times now visiting. And but just to say that he had a long and distinguished career both at the bar as a barrister and then Queen's Counsel, and then about 15 years, I believe, on the Supreme Court. And Trevorrow was just one of a number of really interesting judgments that His Honour delivered. So the format that we're going to adopt is fairly informal. I'm going to ask some leading questions, and Tom will take those questions and fashion answers as he wants to take them. And then we want to leave some time, plenty of time, for you to ask questions of the judge. So the Trevorrow case, I mean, the facts themselves are tragic and sort of a really classic example of the extreme injustice that's suffered by Indigenous Australians, or injustices that have been suffered in Australia. And so I wonder, and let me know if you need a drink of water as well, you all right? I wonder if you could give us an outline of the case. So what was the story of Bruce Trevorrow, and what was the context in which this case came before you?
Bruce Trevorrow was born in November 1956. He lived with his parents, Joe and Thora, and his siblings, including 2 older brothers who have some relatives later. They lived at 1 Mile Camp out of Njarrindjeri in South Australia, about 100 miles then from Adelaide. It was 1 mile camp because unless there was a permit, Indigenous people could not live within 1 mile of a white town. They lived in a very humble circumstances, that the children were well cared for. It was a happy family, they were well fed, they were healthy. Christmas 1957 saw Bruce ill with gastroenteritis. His father was very worried about him, tried to get help from the White Township Tailem Bend, and they wouldn't help. A neighbour had a car, and he provided the neighbour to drive to Adelaide to the Children's Hospital and take Bruce there and leave it. which the neighbour did. He was there for 7 days and was then well to go home, but he didn't go home. The Aboriginal Protection Board decided they would hand him to foster parents. No formalities. Martha Davies, an English immigrant, with her husband, came wanting to foster a baby girl. And they saw Bruce, small curls, and thought he was a young girl. Took him home, and he was there for another 8 to 10 years. It didn't go well. For a while, all was happy, but then Bruce started to recognise he was different, and problems developed. And of course, he had been separated from his birth mother. And there's clear medical evidence at that time, and subsequently, that causes irreparable harm. And it did to Bruce. He became very depressed and was being treated with antidepressive drugs as an 8 to 9 year old. Things weren't going well. Bruce's mother, who was had 1 mile camp, had a friend write a letter for her to the authorities in Adelaide, saying, "I know my baby Bruce is there. When is he coming home? Is he well?" And the response from the almoner was that the doctors say that Bruce is not fit to come home yet, and he's been looked after. And that was 6 weeks after he'd been sent out to foster parents, having fully recovered from his minor illness, as it turned out. The Aboriginal Protection Board at the time had had advice from the South Australian Crown Solicitor in 1949 and 1953 that they didn't have the power to remove a child from the parents except in special circumstances, and those circumstances didn't exist. So the taking of Bruce into this informal foster arrangement was against the law. It was illegal. There's no clear explanation as to why that occurred. These are events from 60 years earlier, and documents had been lost. The almoner who had made this written this letter was dead. So it's a question of trying to piece together the facts from a series of records in documents. After a period of about 8 years, the law in South Australia changed. And whereas before the state had been the guardian of Aboriginal children, now guardianship reverted to Thora, Bruce's mother. His father was now dead. He never saw his father again. The state then decided to return him to his mother. In the first place, they'd made no preparation with his foster family to educate them or inform them how they should deal with the child. Martha Davies couldn't cope, said take him away, and they did. She didn't even say goodbye to him. He was sent to his mother, who had now moved to Victor Harbour with a number of the siblings. He went there and didn't fit in because he hadn't had that upbringing in the culture of the Indigenous people to whom he belonged. He was a stranger to them. He was now a boy with no contact in any world at all. He fell out with his mother and his siblings straight away pretty well, started to walk back to Adelaide, picked up by the police and put into institutional care. And there he remained until AD. He'd suffered some form of mild brain injury, and his education was minimal, and he wasn't really provided with any form of assistance about returning to an Indigenous family, and the white family had decided him. All these are circumstances where he was taken with his parents without their authority, without any legal basis to do so. His life thereafter was tragic. Unsurprisingly, he took to alcohol. His depression, serious bouts of depression. He married an Indigenous woman, Victoria, but he couldn't fit in with her family. He attempted to return to his own Indigenous peoples, the Njarrindjeri, and he was simply at a loss to fit in. He'd never learned the traditions and the customs. So he was, in effect, a misfit. He had employment from time to time. He was good-natured. He didn't have much of a brush with the criminal law system. And then in 1997, he learned that he'd been taken without authority, and the Aboriginal legal rights movement in Adelaide started the proceedings and led to the case. So, Bruce's two brothers, Tom and George, by contrast, had very successful lives. They were proud members of their Indigenous communities. They started a camp, a place which is really a teaching institution about the Aboriginal ways of their peoples. And this was being developed in the 80s and 90s in South Australia. It was really quite an advanced STEM at that time. It was an education institution, and school children from Adelaide would be bused to their centre to learn about the Aboriginal ways. It was highly successful. Tom spoke in the United Nations in regard to Indigenous matters. They were very competent, successful, well-balanced members of the Aboriginal and the Australian community. What a contrast for Bruce. So by way of background, that is the simple story. Obviously it's more complicated than that. But that is the essence of the case. And when one looks back at that, it's a case that cries out for some form of legal redress on the face of it. That then started with litigation, which of course was hard fought. The state government gave no quarter. Both sides were well represented. A Victorian QC, Julian Burnside, represented Bruce Trevorrow, who was Queen's Counsel representing the state of South Australia. So the case was very well presented to me as a judge. It covered a number of areas of law. She was taught, breach of duty of care, false imprisonment, and misfeasance in public office because of the deliberate nature of the wrongdoing, breach of fiduciary duty, issues about evidentiary issues about limitations of time. Hence a very long judgment. But today we're going to focus on the question of the equity issues in the case, and in particular fiduciary duties.
Thank you. I mean, that just brings it to life, that description, that telling of the story. I want, before we look at fiduciary law, we talked yesterday about the issue of how witnesses gave evidence. Do you just want to say a little bit about that and how you managed that aspect of the hearing?
The taking of Indigenous evidence, particularly from older Indigenous people, causes some difficulties. They're not comfortable with necessary English, which is a second language, and they're not comfortable with the court process and the idea of a direct question and answer, and they're not comfortable with cross-examination. They're technically out of courts that don't really allow them to tell their stories. And I'd encountered this as a barrister where I worked in Northern Territory in various cases. So I was aware of these problems. So I explained to counsel in the case that I expected the Indigenous witnesses, and there were quite a number, who needed to tell their story in their own way, much more a narrative than a question and answer, to be allowed to do so. And I didn't want them interrupted. I didn't want objections. I wanted them to have the chance to tell their story in their own way, at their own time. I said to counsel, if in that process material comes out that's admissible, well then an award, but we can strike it out. In this civil case, a judge can do that. I said that if there are problems that do develop and your authority to present your cases for, then we can discuss it. As it turned out, there were no problems. And in fact, some questions would be asked and there'd be quite a long narrative answer when, for example, Bruce Trevorrow would describe his life. Now, he had poor memory, he's still suffering from alcoholism, and so he told his story in a patently honest way. His siblings, who had been exposed to perhaps better education, were far more fluent. So that enabled me to hear their story in a way that they wouldn't tell me. I mentioned that after the case was over, I had a letter from Julian Burnside. It's unusual for a judge to get a letter from counsel. He said he'd been asked to write to me, but by Bruce Trevorrow. And Bruce Trevorrow wanted to thank me for treating him well in the witness box. And I replied that I was pleased that he'd already been treated well, because he's had the same treatment as any other witness. But obviously, amongst his peers, there'd been some who hadn't thought they'd been treated very well. So I was satisfied that that part of the case went well.
So let's move to fiduciary law then, and I guess we're interested in why you thought it was important to make findings on the fiduciary claim, and also were you conscious that you were pushing the boundaries of fiduciary law in this case?
The issue of fiduciary duty, in my mind, had a particular importance to the case. I expected there to be a strong case in tort, in false imprisonment, in misuse of office. So in that sense, equity was a bit of a make-weight. But then I thought breach of fiduciary duty is very important because I was aware of a High Court case which the High Court had said that there was a fiduciary duty to inform somebody who obtained their majority about their legal rights. It's a case of benefit to the community welfare. And some of the judges spoke of that as a fiduciary duty. And when I looked at the extension of time pursuing this case, I was aware that would become a very relevant point. So I was interested to raise that, and counsel in event raised it with through the pleadings in the case. So I was aware that there were limitations on the court's approach to fiduciary duty, and I might say that I didn't feel comfortable with those limitations. I was aware of Michael Kirby's views, which of course extended to fiduciary obligations beyond prescriptive into prescriptive. I was aware of the observations of the High Court in the Breen and Williams, a doctor-patient case that you had studied, dealing with fiduciary obligations of doctor-patient relationship, and speaking quite strongly about duties being prescriptive and not prescriptive. But that struck me as being very odd. I saw this case of Trevorrow as being quite distinct from a doctor-patient case. I was dealing here with a child who'd been taken from his family, for whom the state was in a coordinated relationship, who couldn't defend himself at all, was simply at the state's mercy. And that seemed to be a very different case to the case of the patient. I was aware that there were examples of prescriptive duties in fiduciary relationships and other areas in the area of trusts, directors' duties and so on. So what was I to do? I decided by the time I go to write my judgment that Trevorrow would recover in tort, and I'd satisfied there'd be no further damages that would flow from fiduciary. So I decided that I would express my view, but be quite short about it, and that as it didn't really affect the ultimate damages, and simply run that gauntlet. But then, having looked at this area a little, I could have written quite a treatise on it. I could have explained, for example, how good terms like prescriptive and prescriptive are simply labels. I could have spoken about how one, through the English language, can convert a negative obligation into a positive obligation. Take, for example, that fundamental duty of fiduciaries not to act in conflict. There's a potential conflict arises what you do. There are a series of positive duties that must be followed through, and they tied in with the obligation. And the full court in South Australia disagreed about fiduciary obligations. They agreed it was a fiduciary relationship, but said there were no relevant obligations. They use the expression that usually the obligations are prescriptive. Usually they're prescriptive. The word usually is there. So that very conservative and very able equity lawyer, Chief Justice Doyle, was very careful. I'm sure you wrote that part of the joint judgment. It's very careful to express that. As even in Breen and Williams, if you look closely at the judgments there, you can see differences coming out in the language of Justice Camo compared to some of the other judges. And at the back of my mind, I had the case of Bennett and the community welfare, decided I think 4 years before Breen and Williams, where the judges had been uncomfortable with the description of fiduciary duty obligation to inform the plaintiff that there'd been a wrong done to him and he had legal rights. And that seemed to me to be a prescriptive obligation. Bennett and the community welfare is a very difficult case because the case was pleaded tort, but the trial judge described this as a fiduciary obligation. But it got to the High Court. They thought, what do you do with this? But in their language, they seem to accept that this would be treated as a fiduciary obligation and it's of a prescriptive nature. So I relied on that, and I referred to Breen and Williams, and I decided not to go into the never-ending debate about proscriptive and prescriptive. But I do note that in academic publications since my judgment, there's been an increasing trend to suggest that this dichotomy should not be pursued. It's unhelpful. The real question to decide is, do we have a fiduciary relationship here? And in the circumstances, are there obligations? And in the circumstances, what are the natures of obligations? And I come back to the case of a defenceless child being taken from the parents. They're in the overarching duty of obviously the loyalty to that child's interests and an obligation to see that child is properly cared for. And that is really stems from this relationship toward guardian and ward, rather than a tort relationship of neighbour. So, not a long-winded way.
No, it's really interesting, and it is a question that won't go away. Actually, what
I'm fairly confident that your legal lifetime, and by that I mean proximate, perhaps 10 years, will see a change.
Oh, okay. No, that's fascinating. I really hope we do see some in-depth discussion of the questions by the High Court.
Well, with the new Chief Justice, it may be that equity might get a run again. So that's been had one for a while. Because really these cases that you're studying now go back 30 years. That old, even in Canadian jurisprudence, which enlarged this whole idea of nature's obligations, even that's 30 plus years old. And we're seeing a change in regard to the approach to damages. Whereas in Australia, we've still got this dichotomy, common law and equity damages, sharp line between the two. That's gone in Canada and it's gone in England. But we still refer to old English law that's since been moved on. So I think that I'm a great believer that at the end of the day, the judge has to decide the justice of the case, and equity and fiduciary duties will allow that when other somebody available.
And that's a very equity-centred approach, isn't it, to look for the real justice of the case. So I'm sure we'll come back to that in the discussion time, but I just wanted to ask you before we open it up for questions, and of course you've noted that on appeal, the matter was appealed. You might want to say something about that. And you were overruled on the fiduciary aspect of your judgment, but of course not on other aspects. So Bruce Trevorrow succeeded in gaining a remedy or remedies. But what do you think is the legacy of this case more broadly? And do you think that private law claims, and particularly equity, does have a role to play still in providing justice for Indigenous Australians?
I think the case does have a legacy. I think the judgments will, as all judgments do, fade with time, like judges say. Come old views and fade. But the Trevorrow case provoked a lot of academic discussion. It provoked worldwide press cover. It was one of the matters mentioned by the Prime Minister right in the apology. It's received commentary in both federal and state parliaments. It's been the subject of a book. All these matters permeate the public awareness of these issues. I don't think there'd be anybody today who would say that Bruce Trevorrow did not deserve justice in the case. I think there's been a big change in regard to Indigenous association with the land between 2005, when this case was argued, and 2023. There's now a much acuter awareness of the Indigenous association with country, with the lands. And notwithstanding colonial settlement, notwithstanding the lands being taken, that association with the land has been maintained. And in the last decade or so, that has received widespread acceptance. So in my judgment, when I identified the fiduciary obligations that were owed to Bruce, I spoke about his proprietary obligations. I had in mind his associations with the land. And I think time has shown that to be more and more important. So what Bruce Trevorrow really lost was his cultural Indigenous awareness of his land. He had an innate awareness of it without the education that his peers received. So I don't think I'll be surprised if there's another stolen generation case. I think most will be resolved by agreement. And various states have developed their reparation legislation, and there has been compensation paid. And that generation of stolen children from the 50s and the 60s, 70s, and they've aged. And so I think that the ability to mount another case is probably limited. I mean, they are horrendous bits of litigation to run. You can hear the court. It's really David Goliath in the state. But the legacy has been in the wider impact, the public awareness, the reparations that have followed, the stolen generation apology by Rudd. These are important matters, and so I think that is the legacy. The case itself, I don't know how many of you see this, but there's a small book that was given to first-year law students at ANU that deal with Indigenous issues. And in that, there's a chapter on Trevorrow. And amongst the papers there's a judgement. It's a judgment written by an Indigenous student on the issue of forced imprisonment, which I was reversed. Well, this judgment was usually 5 years. It's actually a judgment allowing an appeal from the full court on that issue. And on this, let's say, this author really takes that full court judgment apart. I reasoned that Bruce had been taken, removed from his usual life, effectively imprisoned with another family, and although he wasn't aware of it, it didn't matter. It's a bit like a child being kidnapped. The fact that child's not aware of it, but still be kidnapped. And so I, in accordance with British and Canadian authority, decided to invite damages for that. A full court disagreed. I personally think the reasons found very flawed. They talked about, well, he had a home and he had a life, but that's not the point. A kidnapped child could be given a home and a life, but nonetheless remains kidnapped. But I thought this judgment here of reparations pretty well put together.
I'll give you the citation for that. I haven't given it to the students because the author doesn't deal with the fiduciary aspect of the case. But yeah, you're right. It's a really important chapter.
Of the case is that I think has been a teaching text in most law schools around the country. So, particularly on tort, but also other aspects. So I might say, as a judge who laboured a fair while on the site, that I'm quite pleased to still being used to teaching text years later. And again, that's going to bring the injustices to the Indigenous people, the way it might be dealt with by reparation, it gives a currency that it would otherwise have.
Yeah, agree. And plus, just reading at the start of your judgment, that narrative of the story, it's compelling reading. So I think it's really important in that respect.
After the judgment came out, Bruce Trevorrow spoke to the press, and I asked him what he thought of it. I can't remember the exact words, but the effect of his answer was, I don't mind if we lose an appeal. I don't mind if I don't get any money. What was important to me was I had a senior judicial officer accept my story. And I thought that was interesting. In fact, Bruce survived the judgment. He received his compensation. I think he bought a big TV. I put a house for his partner. He died before the appeal was disposed of. But the government had said they were going to pay the damages, would or lose the appeal. That's how, another extraordinary aspect of the case, the emotion in the case, the justice of the case was so strong that the government said, we're going to pay the money, come what may. We want to argue the legal principle. Sorry.
Yeah. Thank you. So, over to you. What are your thoughts and questions? They don't have to be limited to fiduciary law, by the way.
Or to equity.
Or to equity. This is just a great opportunity to speak to the author of the judgment. Yes.
So in the High Court, was it around the no conflict?
In it didn't go to the High Court.
Sorry, yes.
It went to the Court of Appeal.
In the Court of Appeal, sorry. Was it around the no conflict rule where it failed? So
So on appeal, what were the reasons why they rejected the fiduciary claim, or that aspect of your judgment?
They agreed that there was a fiduciary relationship. They accepted, as they had to, because the High Court had said so, that the relationship of guardian and ward was fiduciary. The question then became, what obligations are owed? They were very concerned in their judgment about the wide reach of any conclusion of a duty. If a duty was owed to Bruce, for example, covers the economic and property interests, would that apply to all Aboriginal children for the time of awards of the state? That appears their judgment. I felt, rather slavishly followed Brendan Williams, a case about doctor-patient relationship, and they reasoned from that the duties have to be proscriptive, not prescriptive. And they said, well, the duties I'd identified were prescriptive. That's the nub of their reasons. They went so far as to say that the obligation to act until Bruce Trevorrow that he'd been stolen, taken illegally, there was no fiduciary obligation to tell him that. So they did found, I think they found there's a tortious duty to do that. So they've been taken by the idea that all the relevant relief could be given through tort rather than equity. And there is that line of authority that talks about, well, you don't go to equity when you've got your relief in contract or tort. I reread their reasons this week, and I remain as disillusioned as I did. Hopefully it's read them, but
You can find the relevant paragraphs are on the reading guide to the appellate judgment and also to Justice Gray's judgment. So have a look in the reading guide for the citations.
The point about the appeal judgment is that it's very negative. It doesn't go anywhere. If you picked up and applied that, it'd be very hard to find a fiduciary obligation anywhere. But you've got the obligation that's prescriptive. If when you think about it, every negative obligation can be recast into a positive obligation by a slight tweak of language. You know, the obligation not directing conflict does involve a positive matter, not to act. So it really is tied up in the language, as a number of commentators have said. But if you want to see the different approach in Canadian case, it was discussed with Brendan Williams, Justice Kirby's decision in Williams, a very powerful reason why there should be an obligation. And it does have an impact. It didn't have an impact in Trevorrow on damages. There are other cases where it would, because there's a different test on causation, different way of assessing damages and other issues where there can be some important differences.
That's right. You'll see a couple of weeks' time, I think next week, the attractions of the remedy of equitable compensation. And, for example, compound interest, is often a reason why a plaintiff will seek equitable compensation rather than common law damages. So, other questions?
Yes. So, Trevorrow's trust is remembered as quite an innovative, sort of forward-thinking legal judgment that went against the grain of jurisprudence at the time. And I just wondered, personally, how did you feel making a judgment like that? You've come across very passionately about the subject matter. Did you see it as important? Did you think it was going to be overruled? And more largely, do you think equity demands something different from judges, given that its ethos is in achieving a fair outcome rather than following legal principle?
I thought I was, when I look back now, I thought I was privileged to be a judge in that case. I look back about it as being one of the challenging and important cases that I heard. At the time when it came across my desk, very early on in my chambers, there was a procedural argument, a very dull procedural argument, and it had been in the judge's chambers, and he decided to deal with it. So it came into my chambers, and I thought, well, this is a case I think I'll hang on to. Looks pretty interesting. And as the case developed, I became more or attracted to it as an interesting case. And I also, as time went on, perceived that this was a case, if the law did allow remedy, it should be granted, because of the facts I've outlined. And when the evidence was available that the government acted directly contrary to the repeated advice of the Crown Solicitor, I felt confident this was a case that would lead to a good result from Bruce Trevorrow. I had to wait for the full arguments, the evidence. So I had, I think the case maybe lasted 3 months. There were thousands and thousands of documents we put out, evidence from years earlier. There's a huge issue. The Crown argued every point, and they're quite entitled to. Huge issue about the effects of the separation of a baby from the mother at the age of 1, and the impact of that. And there was psychiatric evidence about that. I had evidence from a medical librarian about the materials available in the 1950s about these issues. So it was really an opportunity to explore all sorts of avenues of history, which I quite enjoyed. And I had good counsel, and as a Supreme Court judge, you can really just dictate your own timetable. So the end result is that as a judge, I had an interest in Indigenous matters. I specifically declined to ever get involved in any committees that discuss those issues, because I saw when that happened, judges could lose their independence. So in my time on the bench, I might have dealt with perhaps maybe 10 significant Indigenous cases. Trevorrow was one of them, and every one of those cases I dealt with very thoroughly with a view to producing a just result. My view, when I was a law student, and I'm going to remember now, equity was my favourite subject. I liked equity because equity was the language of doing justice. If the law got in the way, equity was built. And that attracted me as a young student and as a young barrister. And I still believe that equity has a critical role to play in doing justice, because we've now moved in the last 50 years perhaps to great emphasis on statutes and statutory interpretation, and they so often will produce the artificial result rather than a just and fair result. But it's the law, and in that sense has got to be applied. But equity has a part to play in a lot of those cases. In sentencing and criminal law, for example, there are more and more statutes controlling, limiting the discretion of judges. It's not equity, but the judges invariably have this ultimate discretion in sentencing to do what's fair and just. That's very similar to that very broad approach of equity, of overcoming injustice. So I'm a bit of a fan of equity as a result. Perhaps I should have written more on fiduciary duty and Trevorrow.
That's what we like to hear. That's what we like to hear. And it's, I must say, the fiduciary cases and third-party liability cases, they continue to be litigated on equity grounds, even though there's a lot of statutory regulation nowadays, and there are always statutory claims available, but you still see the equity doctrines taking centre stage in a lot of litigation. Yeah. Anyway, Liz.
Thank you for your time for important as well. You referred before about how on appeal the full court was potentially, I think from my understanding of what you said, that they were concerned that there would be more cases of all Aboriginal children who was of the state at the time. And I've sort of read a little bit about that in the past, but what I want to see are what's the difference in the circumstances between the situation and circumstances of Bruce and Kadafulai and that of other laws of the state, and do you think that was a contributing factor in the way they intentionally made their decision, because there are so many children who are laws of the state who are Indigenous?
I think it's that part of affecting 150s. The vast majority of, under legislation, all that we're talking were designated as laws of the state. And then the state had certain powers to act, but it couldn't remove the children from the parents without special circumstances existing. And then that law changed in about the 1960s, and the guardianship is returned to the parents of the child. But white children at the time were nowhere near as dear as, I don't have a position now, as we do hear about the cases of children being taken to care frequently. I'm not quite sure that I follow the problem.
So was the question is about the floodgates argument, is it?
I guess my understanding that Bruce Trevorrow wasn't kind of formally part, he wasn't, because of the particular circumstance. So I guess the law is about for South Australia that he wasn't part of the stolen generation, or was he?
He was certainly part of the stolen generation.
He was?
In the sense that he was taken from his parents, put elsewhere.
Yeah.
He wasn't part of the rounding up of children who went on in parts of Western Australia and what have you. He wasn't part of that. The state was concerned that if there was a finding of a fiduciary obligation to look after in a proactive way, in a prescriptive way, the interests of all these children would become well beyond the ability of the state to manage it. And that's the line the full court took him out. The answer to that is, the reason why Bruce Trevorrow was a standout case was because he was in fact taken illegally, held illegally, against specific written legal advice. You can't do that. The other cases aren't in that category. The cases of that failed, and Williams and Cabillo didn't have that feature to them. And that's why some courts have said, well, there's nothing very new about the law in Trevorrow. It's really applying established law to the facts that in a sense it was. I was acutely aware of the prospect of an appeal, being very careful in my judgment to try to make sure I covered every aspect as far as I could on conventional law.
Yeah. Sarah.
Thank you very much, Justice Gray. That was marvellous. So enjoyable to hear about the very progressive judgment. And thank you, Pauline, for welcoming us to Ask Outside Every Award. On Pauline's original masterclass recording from your judgment, I really enjoyed hearing about the narrative. And part of my perspective is having studied a PhD on the case of the Queen and unlawfully, 2001, which was Justice Stephen Njarrindjeri umpires. So I'm aware we're in such different times now. Just here at AMU, a month or so ago, we had Marcia Langton and our Corn Mod presentation with law book. But if I spin my mind back to 2007 or 2001, so the O'Loughlin case, what are some of the key cases that followed on from your judgment or O'Loughlin that have been progressive, that has built on your, maybe if we focus on your narrative, your emphasis on narrative, like the Indigenous people have that mind with?
Well, I don't think there have been any other Indigenous cases. And I think that there may have been, but I'm not aware of them. None that have attracted a lot of publicity. But there has been a lot of publicity following Trevorrow about the reparation schemes. The various, I think Tasmania introduced one, New South Wales introduced, I think, reparation scheme. And Victoria, South Australia did. And it wasn't providing a level of compensation I awarded to Trevorrow. But he, with interest, etc., his award was something like $800,000, which in 2007 was substantial sum. The reparation schemes are for lesser amounts, but then the people prefer that to running the risk of major litigation. I mean, to mount one of these cases is quite an enormous exercise.
That's the risk in that is just held and not being validated. And I'm also interested in...
Well, I think we better close off the formal part of the class, and then if the judge is willing to stay a bit longer outside in the foyer, we'll continue on discussion for those who want to stay. But I'm conscious there's another class coming in here now. So I just want to thank you very much. It's been an absolute privilege for us to hear you speak about your judgment and so many things to think about from it, including the fact that it's had such a legacy beyond the law, but also very interesting questions about fiduciary law. So thank you very much for your time.